Thanks very much to Duncan for inviting me down for this technical seminar. And just by way of introduction, 2 out of 3 of you know me, but I'm Tony Martin, AJM Surveyors. We've been specialising in dilapidations in the main for about 17 years. It's a practice that I set up and still very much involved in it on a day-to-day basis. The objectives of this seminar is to update you on the protocol. Now, the protocol people have been talking about for a long time, but it actually amazingly came into be law on the 1st of January 2012. So there are changes to look at. Also, I'd like to briefly look at the 6th edition of the RICS Dilapidations Guidance Note. It's not a rule book for surveyors, but it certainly is the standard that dilapidation surveyors would be judged by. And then, in the light of those 2 new documents, new this year, and the changes that they involve, I'd like to look at how you, as predominantly I believe you represent landlords, not tenants, how you can optimise your entitlements, because those 2 documents certainly put the landlord and tenant relationship in terms of dilapidations on a very different footing, and perhaps you need to optimise your strategy. The format of the presentation is very much a PowerPoint, and probably it might be better to deal with questions at the end, but if there's anything that jumps out and you want to discuss it now, very happy to do that. So otherwise I'll roll through and we'll look at the protocol. Well, what does the protocol look like? Well, that's it. It's a fairly dry document. It's been kicking around since 2002. And I think nobody ever really thought it would become law. But like a lot of pre-action protocols, they've come out of CPR and the Wolf reforms, and they're really about trying to keep dilapidations disputes out of court, or at least keep those out of court that seem to take a year or 2 to get there, and then the judge throws them out within the first count. Because I'm afraid, as we all know, there's a lot of egos involved with landlord and tenant, and the courts want to be absolutely sure that the represented parties have been to the ends of the earth to try and resolve a matter before it hits the court and the court have to decide for them. So that's the intentions, and I think we should just look a bit more closely at the actual wording. It's to encourage the parties to a dispute to exchange full information before proceedings are issued, to enable the parties to avoid litigation where possible and support the efficient management of proceedings. So, as I was saying, it's to really try and flush out all the issues prior to people going to court or issuing proceedings. Now, as it is law, there is penalties if you don't comply. Now, compliance doesn't mean there are timescales, but compliance doesn't strictly mean if you're a day out the timescales, automatically you lose your case. The timescales are for guidance only, but if you did actually ignore them significantly and ignored the case management procedures, then it's likely that even though you might win the case in terms of the actual settlement, the costs might be awarded against you because you didn't conduct the case in accordance with the protocol. So we're yet to see, it came in on the 1st of Jan, we're yet to see a lot of cases come through where perhaps the protocol hasn't been obeyed or followed. So we're yet to see quite how the judges will award costs, but it's happened in other areas where there are protocols and costs get totally awarded against a party that ignores the protocol. These are the big components of the protocol that you may or may not know about. We've got endorsements. For years now, when we've acted for landlords, we've had to put a statement of truth effectively in there to say that these works are honestly and truthfully required, that we've sought the landlord's intentions and no, he's not about to knock the building down. And the other factor is that the costs that we put down are reasonable market costs for putting the work back in repair. So that's what the landlord's endorsement has had to say for quite a while. And now, for the first time, the tenant has to do an equal endorsement. And the tenant has to say, I've considered what the landlord says, and I honestly believe that this is the real value of a disrepair, and I believe that the costs that I'm putting forward are realistic costs. So it's almost a parallel for what the landlord has to say, and now the tenant has to be truthful as well. A nice balance. In terms of timing, we've got the word 56 days is the key for everything, so a couple of months. your quantified demand, and I'll talk about that a little bit more in a moment, has to be served within 56 days of lease end, lease break, end of the lease. And then the tenant has 56 days from receipt of the quantified demand to actually respond. So although I personally feel 56 days is still a hell of a long time when you're waiting for a response if you're a landlord, at least there is a timescale. Prior to this there was no timescale, and I don't think it's occurred on any cases I've worked with you guys, but you know, delapse cases can occur any time up to the statute of limitations, sort of 12 years later, so it's a long game. Now the quantified demand, I said that the quantified demand had to be served within 56 days of lease end, but it's a new term, quantified demand, that came in with the protocol. And previously we probably all called it the statement of claim. But the statement of claim perhaps in the past has been looked upon as a little bit being wishful. This is really what the landlord would like to achieve, but he probably expects he'll only get half of that or something. But the quantified demand is something very different. The quantified demand is almost like a rent demand that you guys might send out. It specifically says that we've taken into account everything. This is our loss, genuinely, and you must pay it. And that's why the quantified demand carries a lot of weight. And it also carries a lot of responsibility for us as your consultants to put that document together, because it can't be spurious, it can't be fraudulent, and it genuinely needs to have taken into account even an informal diminution valuation. And I'll come on to that a little bit later. So it's an all-encompassing, genuine demand for money. And in that sense, it's quite an authoritative document. The pre-action period, you have to reveal everything that you would reveal to the court, so it's no use holding back on anything that you think appertains to the case. Often, as we know, leases says no better than the schedule of condition, nobody's got the thing, or maybe one party's got it and one hasn't. Now both parties need to share and make sure that they're actually working from the same documents. And ADR is a new one as well, and most popular or most common ADR for dilapidations is mediation. And again, if one party says that prior to proceedings, I think we should resolve this by ADR or mediation, if the other party unreasonably dismisses it, and I think that reasonable word will be subject to a lot of the usual legal verification. But if one party just says, well, I just don't want to consider mediation, no particular reason, I just don't want to, I want my day in court, that could again be another reason why the courts, if they felt the mediation perhaps was the way forward, why the courts might apply costs even if you've won your case, costs against you. And in the future, I think we're 11 months down since this has come into force, and I think there's only going to be a tightening up on the procedure, so it's going to be interesting to see how this changes. The other change this year for us in the dilapidations world has been this document here, which is the RSS guidance note, and it's really been established to tie in with the changes in the protocol. And really for us as surveyors in this area, it really has brought about a change in how we go about it, because we can't just load costs against items that we've plucked from here and we think are probably about right. We need to prove those costs. We need to say that those costs have derived from something. It could be a building we did down the road that's very similar and use quantified rates that we can transfer. It could be a cost book, BCIS, Building Cost Information Service, a cost book, or it could be some sort of in-house data that we've collated. And we are collating a lot of costs because costs need to be proven. And I think in the past, building surveyors particularly tended to say, well, the services look a bit ragged, I think we'll stick in £1,000 for that or something. Whereas now it's, if you can imagine, when you come down to this quantified demand, it's got to be your real losses. And that means that you can't just say, well, the lift is worn out, or you need to actually conduct specialist surveys of all these areas. So we need a more careful procedure of looking at all the losses, and there is risk potentially of somebody saying that a claim put together without a cost basis is fraudulent, and this is probably kicking around within the RICS quite a lot. Questions about what is fraudulent and what isn't. There's not so much room for saying it's a mistake as there has been in the past. We've talked briefly about the quantified demand. It is a really detailed, proven statement of your losses, taking into account all elements of the loss. And I'd like to divert ourselves a little bit when we're looking at assessment of loss, and I'd like to introduce you to three friends of mine. And as there are conveniently three of you, I'm going to give you one each. But what I'd like you to do is I'd like you to, they're pull-back and drive cars. So I'd like you to have a go, and I'd like you to aim to crash the cars into each other. And it would be really good if at least one crashed into the other. Oh. Okay, you had a near miss there. I'm going to help out. Oh, right. Okay. You ruined. Now, this could take some time, but this is what I like. This is what I like. So, this has happened. I mean, I think personally the blue car was pretty much to blame for that one. So, the blue car has willfully crashed into the red car. Now, the red car, quite rightly, is going to take his car off to the repairers, and he's going to get a list of the damage done, and he's going to expect the blue guy to pay for it. So he's taken his car off. It needs a new bumper, it needs new lights, you know, it's in a pretty bad way. And the bill, as we know, for car repair bills is a couple of £1,000s. Now the problem here is that this isn't the new shape Mini, this one. This is an older one, it's got a little bit of rust here and there, and to be honest, that Mini is worth £500. So he goes to Mr. Blue Car and he says, it was your mistake, do you accept that? Broadly, the blue guy says, yes, I do. And he says, it's going to cost me £2,000. And here's a bill, and I've really broken it down. In fact, I've got 3 quotes, and this is the cheapest of the 3 quotes to repair my beautiful Mini. And the blue guy says, well, that's great, and that's really interesting. But the problem is, your car was only worth £500 when I hit it. And my guessing is, does it still drive? Yeah, it does. If you put a new headlight in there so that it complies with the law, you'll be able to drive it and it won't be worth significantly less. In fact, I bet it's worth £100 less. What I'm trying to introduce to you in an incredibly simplistic manner is that although we can draw up very nice schedules that show that there's £1 million worth of loss potentially to a building, when we come to do our quantified demand, we would have to look at the wider aspects and say, well, actually, this building, perhaps it's in an undesirable area, and London's not a particularly good example of this, but you know, actually most of the country apart from London at the moment is an undesirable area. So if your building is in an undesirable area, it may have £1 million worth of loss, but actually if that building went to auction, it would be worth this price in its current dilapidated state, but it wouldn't be worth a lot different if you spent £1 million on it. So this is where the diminution comes in. And we now as surveyors need to have a view towards the caps that might be imposed by the assessment of loss, and the Minis was a simple example of that.
So you just take into account investment values and that sort of thing?
Yeah, I mean,
it's not traditionally known to specialise, is it?
No, not traditionally. I mean, when they were muting the new protocol, they were saying that every schedule had to be served with a diminution valuation. And that was debated and kicked around and quite rightly decided to be totally unreasonable. But I think probably for us humble building surveyors, there are buildings that shout that the building perhaps has come to the end of its life. And I've got one I'm working on at the moment, which is like a Northern Light warehouse just north of Manchester. And the building is at the end of its life. And there is a lot of disrepair. But, you know, I've advised my client that I think he should get a diminution valuation carried out, not to serve with the schedule, but to actually guide him whether the schedule is going to be significantly impaired or possibly not worth doing. I mean, it could be demolition value alone. So recent data shows that average lease lengths are now 4.8 years. And I thought what I would do is, in the light of these 2 documents and how they perhaps are more tools for a tenant in order to reduce claims than for a landlord in order to achieve his full entitlement. I thought we would look at a typical 4.8-year lease and say, well, what can the landlord do at particular stages and times in that lease to perhaps try and protect and optimise his position. So our next slide really tries to explain why the landlords are under pressure at the moment. Well, the RICS have completed some data which shows that the average outcome for a landlord's claim is at the moment something like 52% of what they started with. Now, they haven't quite said whether that's because landlords and their surveyors are being excessively optimistic, or whether maybe that's just a sign of the negotiation and preparation abilities of the market generally, which is very variable. Our data really shows that we tend for landlords to achieve about 74% of what we claim, and I would like to think that's because we're particularly good at what we do, but perhaps we're more realistic in how we set the documents out. So there's a general belt tightening in the market. Landlords want as much as they can, tenants want to pay as little as possible, so that causes stress. There's stress for landlords now in the fact that when they need to put their claim on the table, it needs to be really thorough and thought out, and probably it might have half a dozen specialist surveys. So it's a big upfront cost. And of course, the RICS is pushing very heavily the loss situation, which is a bit like our minis. So they're making every surveyor aware when they turn up to a building to do a schedule on, and maybe they're looking at a landlord schedule in front of them. Do we think that this loss can be justified by a diminution? So all these things are really counting against you, Mr. Landlord, I'm afraid. And how I thought we'd do it is looking at a life cycle analysis. So the lease starts here, ticks round, 4.8 years later, it ends here. And then you've got a reletting period, which of course is variable in time. This might be tiny or it might be really huge. But this is just to give us an idea. So I would say that the normal term of the lease, and of course the review period is part of the lease as well, but the normal term of the lease is probably this period here. And let's see what you can do in dilapidations terms, because you might think in the first maybe 2.5, 3 years of lease or something, there's really no role for dilapidations. You know, what can we do? So are there any protocol considerations? Well, there aren't really, because the protocol kicks in when the lease ends, not before. Although the schedules you serve before have to be protocol compliant. So what can you do during the normal term of the lease? Well, if a tenant wasn't repairing and you were really unhappy about it, then you could serve an interim schedule. Now, interim schedules are not that common now because of the power of the Leasehold Property Repairs Act 38. And what that essentially says is that unless the place is not wind and weather tight, and in very bad state of repair, then the tenant will get relief. So if you think it's cosmetically poor or the defects to it are relatively small, it's not worth serving an interim schedule, because they will seek relief under the Act and that relief will be given. So interim schedules have been sort of neutered a little bit. Something I would suggest we look at, repairs notices, I'm really pushing at the moment. They sound a little bit aggressive, but the problem for landlords, if they leave disrepair to the end of the lease, is that chances are the tenant will escape doing anything. So if you want the work done, then a repairs notice is the way to go if the lease allows for it. The lease must allow for it. Most modern leases do. There's no relief from a repairs notice as long as a repairs notice is valid and proper. There's no relief. A tenant ignores it at his peril. If he ignores it, the landlord does the work, the landlord charges, and often it can be recovered as rent. So it's a really great way of keeping your clients' buildings in a good state of repair during this normal part of the lease. It is a little bit aggressive, and you would probably, you might suffer a deterioration in relationship with your tenant. But if you've got every indication that the tenant is not repairing the building and perhaps hopes to get off scot-free at the lease end, I would encourage this as a way to go.
How does a repair notice varies from an interim schedule?
It's quite significant. An interim schedule you can get relief from. But are you saying physically how does it differ?
Well, yeah, I mean, so you're saying a tenant get relief from an interim schedule but not from the repairs notice?
Correct. So the repairs notice is distinctly different because it's got two things. It's got a timing, it's got a specific item of repair and it's got a specific timing to do it. And usually in the lease it says that upon receipt the tenant's got 3 months to specify, carry out and complete the work, full stop. And if he doesn't, it's got a remedy, which is a landlord can go in and do. And we're doing quite a lot of repairs notices at the moment, particularly on industrial buildings and bigger buildings.
And interim schedules don't have that ability?
Interim schedules generally get served and the tenant immediately seeks relief under the 38 Act and does nothing. Even if we feel that they shouldn't be seeking relief, their first gut instinct is to seek relief.
So is a repairs notice quite a new
No. No, repairs notices are really Jervis-Harris clause. They've been in for, it's been acknowledged that they've been a powerful resource since Jervis and Harris, which is probably approaching 20 years ago now. And and there was quite a flurry of excitement at the time, about 15, 20 years ago. But there's another flurry of excitement with repairs notices now because landlords are realising that it could be their only way. I'll give you an example. If you have got a building that you believe is going to be significantly impaired by a diminution valuation at the end of the term, i.e. whatever state of repair it's in, you're not going to get anything, then you could serve a repairs notice. A repairs notice isn't subject to a diminution valuation. So even though it could be uneconomic in terms of market values to do the repairs to this building, if the lease requires that work to be done and it's during the period of the lease, if you serve a repairs notice, then you can get financial restitution. It's probably your only route as a landlord for doing that. So it's a good foil to the diminution valuation that occurs at lease end or can occur. So let's look at the next review period. So the lease is still current, but you're in the final term of the lease, whatever the term may be. And again, protocol considerations, well, technically they don't apply because the lease hasn't ended. I think during this period you should be looking to serve a draft terminal schedule. Now in the past people have served terminal schedules before the lease has ended and called it a terminal schedule. It's not. It's an indication of the likely disrepair at the end of the lease, but it isn't a terminal schedule. Terminal schedule can only occur on the last day of the lease because the tenant can do anything in the meantime. So what you could do here is you could serve a draft terminal schedule that says, well, I've had a look around and unless you significantly repair this building, this is probably likely to form the basis of the terminal schedule. And you might want to speak to your clients or the landlord and say, well, what are we going to do here with this building? And if he says, well, actually, it's coming down, it may not be worth doing that draft schedule. And you can't, perhaps in the past, just sort of seen how you get on. You know, we've got to be honest about intentions. Saying that, landlords put planning applications in to do all sorts of things to their buildings. And of course, in the current market, quite a lot of them can't get funding. So you, as a landlord's agent and the landlord, are entitled to look at the whole range of options. Even if I'm pursuing cases where the landlord's got a planning approval to demolish it and build something else, but he can't fund it at the moment. So he's entitled to pursue whatever he wants, in terms of alternative uses, as long as on the last day of the lease his intention going forward is to rent it, even if it's just for a short term. It's a good period as well to look at any time of the essence reinstatement notices. Seem to be seeing a lot of those, and I'm not quite sure why, but a lot of those say that the landlord has got to let the tenant know in the last 3 months of the lease whether he wants these alterations reinstated or not. And of course, if you don't have that review period and serve like a draft schedule, you might actually miss a notification because a draft schedule is a valid notification to the tenant that actually we do want this reinstated. And it gives you a chance to find all the relevant information. It's, you guys wouldn't be amazed, but I mean, there's lots of bits and bobs of missing licenses and information, particularly when people are acquiring at auction that just don't seem to be there. And actually, if you haven't got the information, under the disclosure rules now, you can say to them, I haven't got it, I would like to look at it. And they can't refuse you. Okay, now we're in the final bit. The lease has ended. We're in the red bit because nobody likes this bit because you're trying to re-let it. What happens now? Well, on the day the lease ends, you as landlord's agent have got 56 days to arrange and serve a quantified demand. If you do it after that, well, the odd week or two probably isn't critical, but beyond that you will significantly damage the possibility of recovering money for dilapidations. So you've got 56 days. It needs to be this quantified demand. It needs to have considered everything and said, this is our shopping list. At the bottom, this is the price. And you literally serve it and you say, pay. If you've done a draft schedule, you'll need to revisit at the end of the lease to update it, because in order to serve a quantified demand, it's got to reflect the loss at the last date, not what you thought it was 3 months or 6 months or a year before. You need to have in writing what the landlord's intentions are. You can't just say he told me on the phone and this is what he wanted to do. You have to give a piece of paper and say these are the landlord's intentions at lease end. They can be fairly broad. I've seen them be fairly broad. What do you do? Well, you could, whilst you're negotiating with the outgoing tenant, you could actually go and do the work. You could put your money where your mouth is and do the work, which is great. Most landlords don't. 2 reasons. A, they don't want to spend the money. They'd rather get the money in from the tenant. And B, they might want some flexibility to offer a rent-free, you know, for the equivalent sum to the new incoming tenant. So they tend not to carry out the works. But the problem is, if you don't carry out the work, you've got a theoretical claim. It could be true, but actually you've not suffered a loss until you've actually carry out the work or find a tenant that wants a rent-free. So you've got a real problem if you don't carry out the work. Also, you've got to look at the reletting. Now, the terms of the reletting are going to be very much going to affect the claim and the negotiation, because if you're reletting, if somebody comes on board and pays the same rent, similar term of lease, doesn't get a rent-free, then actually your claim for loss is 0. So, you know, the effects of the reletting are quite important, and we've got to think about mediation. The tenant could turn around and say, well, I don't like your quantified demand, let's go to mediation. And you've got to think long and hard whether you say I'm not doing that or whether you apply to go to mediation. So, tricky period here. This is why I was saying that if you can get the bulk of the worst disrepair sorted out under a repairs notice at about this stage, you've got far less to fight about at the end of the lease. Now, I appreciate that's not applicable probably on most of the small jobs, but I would say particularly industrial property, particularly large office property, you really want to get the bulk of the work done during the lease, because if you leave it to the end, I'm afraid the tenant has some quite strong defences available to him. So I'd just like to summarise. We've got, this is the key changes by these 2 documents here. We've got the landlord schedules need to be more professional and properly costed. I think you can see that. And the landlord needs to more carefully plan for the lease end. It's not a matter of saying the lease ends, you know, we still get this, the lease ends next Thursday, can you go round? That's absolutely fine. But I don't think the landlord and their agent are optimising their position by doing that. I think they need to look a lot earlier, particularly with larger property, see if there's bits of work that they can enforce a tenant to do before the lease end and try and do that. But the protocol has set out timings before litigation, and it has made the tenant say, I mean, in the past we got a lot of tenant responses that said this is rubbish, it shouldn't cost more than £1,000 or something like that. And I think now we just turn around and say, that's a lovely opinion, but can you sign a statement of truth of that as well? And they're going to be a bit more reticent to do that. So I think maybe the protocol, although it's caused landlords problems, there is an upside. And that's really the 4th point as well. They've got to far more carefully consider how they dispute schedules. So moving to the last point, I'd just like to thank you for inviting me here, and it's always interesting to meet you and see what views people have got about different ideas. I don't know what questions you've got. I thought of a question, just in case you didn't have any questions, but I'm sure you will have. But somebody asked me before, well, at the end of the lease says must comply with statutory requirements, and I want, you know, to re-let this, I want the gas safety test certificate, fire alarm, I want the lift, I want asbestos surveys, I want electrical test certificates, and reasonably you might think you might get those, but my other client was saying, well, we very rarely get all of those. Why is that? Why can't you force them to do that? And it really depends on the wording of that statutory clause in the lease, because quite a lot of statutory breaches are resolved the day the tenant pulls the door up behind him and slams the door. Because a lot of these sort of regulations are more based on how they occupy the building. You know, not the fire certificates apply now, but fire risk assessments is a big one. You know, we can ask for one, but the day the tenant goes, he doesn't need it because it's an empty building. There isn't a fire risk assessment. So, in quite a lot of circumstances, you just can't get those. Likewise, electrical test certificates. If they haven't made any alterations to the fixed wiring, then they don't need to do it. It's only if they've altered things. So, I've answered my own question, but over to you guys now.
I thought electrical test certificates, I thought you had to have them, electrical installations examined every 5 years.
I think you're right, it's every 5 years, but maybe they've got one that they did 5 years ago. But if we've said reinstate different partitions and they had wiring in them, which they do in most cases, then they've made an alteration, they have to update those certificates, yeah.
How often do you actually find the diminution argument being raised?
Every time. Not joking. I mean, by tenants.
Really?
Tenants will scream diminution on virtually every schedule we serve, because why wouldn't they? Well-advised tenants will ask for it every time.
Yeah.
I mean, the general rule of thumb, and I haven't seen this published anywhere, but it's my experience, is that you wouldn't even think about diminution valuations under, let's say, £50,000, £100,000 claims. Because
yeah,
as you and I know, you can get value of 1, 2, 3, 4, and they could argue till the cows come home. It's not sensitive enough to work out different values. My rule of thumb is between, certainly under £50,000, the claim is a cost of works, because valuation techniques are not sensitive enough to really be able to define the difference between the valuers.
Mm.
But
look, I must admit, most of the claims I've got in mind are smaller.
Yeah, I think probably they slip under the net. The protocol was like a recommended way of behaving prior to 1st of Jan 2012. Come 1st of Jan 2012, it's the only way to do dilapidations. And, there are still probably 50% of schedules I see don't comply. And it's, if I'm acting for the landlord or the tenant, the first thing I throw back at them and say, it's not a compliant schedule, let's know when you've got one that is. And I just throw it back at them. And then they have to instruct somebody and they have to do it, because we shouldn't be serving schedules that don't meet the protocol, I'm afraid.
Also, I quite like this idea of repairs notices not being subject to diminution.
Fantastic, isn't it? Well, I mean, actually, if you get to the end of the lease, you could actually just say, we honestly believe this repair needs doing, we need to re-let it in the market, we're just going to go ahead and do it. And once you've expended the money, there's no diminution argument, because you're applying for costs rather than a theoretical loss. Diminution only applies to a theoretical loss. If you've spent the money, you've got an actual loss. The problem is most leases, bigger leases that you might think about doing this for, 10, 15 years ago, and you just can't help yourself from updating the building when you don't want to put a 1980 spec building back on the market. So unfortunately there is supersession. You come across supersession whereby you do things slightly differently because the market's changed and the tenant says, no, I'm not paying for these category of lighting, I just had old fluorescent strips and that's it. So if you do the works at the end, you do risk superseding yourself and reducing the claim. I mean, I've just come from quite a large one in the city and they did a complete refit of the building, but actually certain elements of that refit the previous tenant is liable for, because there's listed elements of it, there's historic elevations, and the repairs to them are you can't really update a historic elevation as much as you'd like to. So certain elements of the claim are lost, and certain elements of the claim are retained. So we've been able to divide between the two and pursue the smaller claim. But repairs notices are great, seen as provocative. We're doing a lot now, and you need to be very careful. I mean, you risk affecting quiet enjoyment if you're doing things internally. So I would say externally works a lot better, because as soon as you disturb a tenant internally, they'll serve an injunction, and it becomes very sticky. But it works really well for decay to elevations. You know, we've got one on site where there's it's effectively got Regent Street disease. You know, the stone is breaking away because of corrosion of the reinforcement and things behind, and we're just going and doing it because there's no way we want to leave that element of disrepair to the lease end and have a debate about diminution. Why should we?
So if you've got a situation where you've got, say, a couple of years left on a lease,
yeah.
The landlord in a couple of years' time is thinking of knocking the building down and redeveloping.
Yeah.
But he wants to take advantage of his tenant while he's there and get as much money out of him as he can. Could he serve a repairs notice on, if say he's got a leaky roof?
Absolutely. He doesn't need to prove future intentions on a repairs notice.
On a repairs notice you don't. There's no.
Yeah, most of the written intentions I see are fairly vague. It's to say that, you know, the landlord has appointed a letting agent to continue to let it in its current format, although you know, all options are being considered, and that's fine. I think what the sort of regulatory bodies are trying to avoid is this situation where a tenant pays £1 million and then drives past the next week and sees it dropped. That's fraudulent. You know, that didn't happen. If somebody had said, well, actually, we're just going to re-let it and see how we get on, and the building comes down, I think probably that is fraudulent. But I think it's a difficult area, and it's difficult for us, it's difficult for the landlords. And it is a changing market, and what you think's the right strategy today might, 6 months of a void, you might start considering anything, you know, so.
Do you actually include diminution of valuations in your reports? Then you don't?
No.
Not unless you're asked for.
There's no requirement. It was thought that there might have to be a requirement to provide one at the same time, but it never transpired in the document that arrived. So right. You need to have, in doing the schedule, you need to have an eye whether you think diminution will play a role in the eventual settlement. And that's probably as near as we get to doing evaluation, because we can't do them. But if a tenant turned around and said, well, I want a diminution valuation because I think it's got a big role to play in capping this settlement, I'd say to them, well, fine, go and get one. It's not the landlord's job to provide it. It's a tenant's defence. Tenant can go and pay his 5 or 10 grand and get his own report.
Oh, right.
So I'd say go ahead and provide it. And they'd say, well, haven't you considered it? And we'd say, yeah, I mean, in broadest terms, we considered it. We didn't think it was relevant. So if you think it's relevant, it's a tenant's defence, you go and do it. And then, you know, when we get the report, obviously, we've got something to send to our client's valuer to see what they think. Thanks everyone for coming along, even though it's your office. And I hope that was helpful to you, and I think there's some valuable questions there. So.
Very much.
Thanks.
Thank you.